So you're accused of using and exhibiting a deadly weapon, namely a handgun, to commit this assault, where apparently beat on the door and pointed a handgun and reached inside the residence, forcefully pulled the victim out. And you have a prior conviction in 2019 of being a felon in possession of a firearm out of Harris County. You know that, and you have a felony before that. So you know that weapons and misuse of weapons have their consequences. And this states, according to the grand jury, you threatened somebody at their home, burst through their home, used a deadly weapon, namely a handgun. Again, you're getting in trouble. No, you have to have a GPS device. If you can't afford it, you go to jail. Okay? You understand?
Yes, sir.
All right. That's all I got to say to you. I'm not tolerating misuse of firearms. And that seems to be your track record. You can shake your head all day long. Don't shake your head at me. You understand? That's the court's order. Do you have a GPS now or not?
No,
Then
sir.
sit over there. Thank you. You're not leaving until we know that the community can be safe when you're walking about misusing firearms. Shame on you. Tell Mr. Adams that we're here. There's a hearing, and I'm going to place his client in jail because he doesn't have the GPS device.
Right here, the judge draws a hard line. This isn't about attitude, it's about control. When a court orders GPS monitoring, that's a legal leash. Shake your head all you want, but ignoring a bond condition is how freedom turns into a jail cell fast.
Thank you.
Does Mr. Adams need to come down?
Yeah. We got to deal with this.
Oh, I did. So that comes.
All right. Yeah. We're going to put him in custody right now. Thank you. All right. This is an issue on,
I'm still in prison, so.
who's here for in this case, Briscoe? If anybody.
Oh,
Oh, good.
It's a GPS device issue. He can't afford, but his file.
You still have it or no?
No.
Here.
Hold on.
I got it. Those are both yes.
The problem we have here is that he is charged with the use or exhibition of a deadly weapon. He is previously convicted of felon in possession of a weapon, which means he had a felony before this 2019 conviction occurred. I don't know what that is, but what I see here is again misuse of a weapon that resulted in a conviction out of Harris County, and then here is misuse of a deadly weapon, namely a handgun, again alleged in this indictment.
This is a key legal moment. The judge isn't guessing, he's building a record. Prior convictions plus a new weapons charge equals elevated scrutiny. In plain terms, once you've proven you can't be trusted with firearms, the court stops giving the benefit of the doubt.
Not to use a firearm irresponsibly. You can't even touch one. It's a crime. Touch it, you got it. You got another crime. The GPS device was something that I want to know where he is, and this court believes is hardly too much to ask for the safety of the community when you've been convicted of misuse of a firearm before, and then now again another aggravated assault with the use of a weapon. Notice the states it's saying, let's see, approached him, advised, the defendant was brandishing a black handgun, pointing at him, stating he would kill him. The victim was in fear of serious bodily injury, entered the residence, and it was shortly after that that the defendant began to beat on the door. Somebody opened the door, and the defendant pointed the handgun at the person and used his hand to reach inside the residence and forcibly pull the person out. So misuse of a firearm is illegal.
Listen to what the judge just admitted here. The system doesn't have a perfect solution. No magic device that beeps when someone touches a gun. So GPS becomes the next best thing. Not punishment, but surveillance in the name of public safety.
He gets near a firearm, but we don't have such a device. So I want to know where he is, because I'm going to think if there's misuse of a firearm around town, my first instinct is to think Alex must be up to something. So yeah, you've got to have a GPS device, and you're going to have to stay at home unless you go to work, go to the doctor, go to get food, the necessities to and from your home in the most direct route possible. That's hardly a lot to ask for when you have a criminal history like this, sir. We're going to keep the community safe as best I can from people who are irresponsible, especially with the misuse of firearms. It's hardly something hard to ask of anybody, but you're going to have to meet the obligation if you want to stay out on a bond. So that's that issue. And until he can get a GPS device, he's going to be in custody. So what are we going to do about it? You can't do it. You can't get one, right?
I really don't. I got to put my child that'll be 24 hours on lunch to 24 hours because he had got hit by a car. So I'm really in the house every day anyway.
That's why it's always, you have obligations on the outside. That's why it's a good deal not to get a criminal charge. And especially when you've got a prior conviction of misuse of a firearm, and here we are, aggravated assault with a deadly weapon. You're looking at, in this case, if all of this is true, you're looking at up to life in prison. You understand? It's a second-degree felony enhanced to a first-degree felony because of a prior conviction. So you're looking at no less than 5 nor more than life imprisonment. You see, it's serious. So this court is certainly going to treat it this way. But what do we do? I asked Mr. Adams to come here to talk to you about your options here. And you need to talk to him about anything. This was kind of a surprise, but I don't want him to leave without getting some advice from you. You take whatever time you need, talk to him about his options.
This is where the stakes explode. Second-degree felony enhanced to first degree? That's legal code for your past just caught up with you. 5 years minimum, life maximum. At this point, bond conditions aren't inconveniences, they're lifelines.
It's just an obligation you have to have. You put yourself in a position where I want to know where you are at all times. If somebody's seen with a firearm, I want to know where you are to see if it was you or not, because you have a track record of misuse of a firearm. We're going to do all we can to keep this county safe as best we can from irresponsible use of firearms.
Judge, I think that a possible help to this situation is that, to my understanding from talking to him, the initial fee is $300 and they want $200 every month on the GPS. If the court would be willing to waive the fees for the GPS, then he can keep the GPS on him. And he's saying that he can't afford that initial $300 payment, and then he can't afford the $200 payment each month.
Well,
If we don't-
Here's the problem. I've just said it and I'm funny about it. I open the door for one, I open the door for everybody. Everybody's going to be in the G, and then who's going to pay for all the GPS device? The GPS has to have, the taxpayers aren't going to pay. It's the obligation of the defendant. But that's what I do. Just like what happened earlier, that door just got open and we're going to be doing, I'll treat people that way from here on. And I'm going to treat him and others the same way. But I'm not, it's a bar you have to jump over. That's why I advise don't commit crimes of violence or threaten violence with firearms. And then we wouldn't have to deal with this. Sorry. And you've got your prior conviction. What was his prior felony that resulted in this Harris County conviction that caused this felon in possession?
That was,
What was your first felony conviction?
possession of control system.
Oh, possession of control. Where? What county?
It was discount.
Jefferson? Okay. Is that what they used in the indictment here in Harris County as your prior
That's what-
conviction, the
that's it.
illegal possession of a controlled substance?
Yes, sir.
Okay. All right. Anybody else want to say anything? No. Did you want to talk to him while you got him here about it? Okay, let me go into the jury room.
Well, we can do that.
Okay.
Let me get.
Then I want to go with the Leo's case here.
All right, come on.
What are you, a couple of things. Number one, what are you doing to get Mr. Cover his information that he
He said this is
needs?
it for Jefferson County.
Sir?
He said that this was it for Jefferson County. So let me, I'm
Okay.
gonna see if I can figure it
Thank
out.
you.
Your Honor, we've already provided in 2231, and we have the discovery ready for him to view today, as well as to get all the copies of the pretrial notice that the state has filed, and that's in 2232, the theft case.
Those are the only two charges you have, right? And
Correct.
okay,
Oh, I'm standby counsel in this case.
stand by.
I'm standby.
Good. And okay, he's filed some new motions for speedy trial. Here's the deal, whatever these aren't going to delay this trial. You're set for November 3rd and you're going to be ready, right?
Okay, I'm ready. I'm
Good.
ready right now.
Good.
Here's my question.
It's first on the list.
Okay,
It's priority.
I do have a question.
Yes, sir.
All right. Now, I didn't know until September the 18th that these two weren't going to be tried together. Every time I've been to court, they've been on both of them together.
Yeah.
When I got rid of the lawyer, they were both of them.
Trials are never tried together in this court. This is this court's decision.
There's an assistant district attorney called Nealon that in her response on my mandamus told the Ninth Court of Appeals that these two cases were being tried together, that I was going to go to trial and
Who's
rely
that?
on them.
Who's,
Okay, now I've never heard anything about this step case until 3 days before the 2 years. On the SPAR discovery on 2231,
when did you first hear about this theft case?
that they was going to be separated, no, September the 18th.
No.
Every time I've been here, they've been together.
Yes, sir. When we have pretrial hearings, we put them together. That's normal and customary. Otherwise I'd have a hearing on one and then I'd stop and then I'd have to do a separate hearing on the other. Which we don't have. Hold on. We don't have the wherewithal to do that. So I put pretrial hearings together. You can shake your head all day.
Well, I don't
Okay.
understand.
But when it comes to trial, this court's decision
Mhm.
is you don't have a right to try them all at one time.
Okay,
And we're going to try one or the other, and hopefully one trial will finish all of this. But generally, this this theft, in 2232, that is a state jail felony, correct?
That's correct, Your Honor, and enhanced with the
You have a motion.
priors. Yeah,
You have a
notice of
motion to
enhancement.
file-
Yes, Your Honor.
What is the punishment range?
Be the that moves it to the second degree.
Because he has prior felony
Yes.
convictions in sequence?
Yes, Your Honor.
Okay. This one, the other 2231, refresh my memory. This also is a state jail felon.
Yes, Your Honor, and that's the same because of the priors. It's enhanced to a second degree felony punishment range, and there's a notice of enhancement that's been filed in that as well.
Okay. Yeah. What I'm going to do is we're going to try, if we have to try this second one, depending upon what happens in the first one, sometimes the second one, they don't go on. It depends on what happens in the first one, a lot of times. But I'm going to turn right around really quickly on, and I mean, in a month,
Yes, sir.
and try another one.
Yes, sir.
But I don't try, never done it, 20 years, not going to do it. And
What?
it's just,
Okay.
it's discretionary with the court. Okay.
Okay, I don't care about the two trials. I don't care about the enhancement.
We'll
I
do
don't
it.
care about the.
We're going to get it as fast as possible.
But this
Which one do you want to go first
I
on?
don't care. This discovery on 2231, Mr. Boyd told me when I'm looking through this, if I wanted copies for when we go to trial, he'd make copies. So I read through it. It's over 5,000 pages. I read what I could get on the computer, and I put down on the thing, the paper I signed, written on there what I wanted the copies of to go to trial. Then he complained that it was too many pages to make
How many-
copies.
what
So
is
I
it?
need to do
Okay,
discovery.
Your Honor,
What's he?
I told Mr. Cover that he had Mr. West, and if he'd like to write down those things, he can assist him in getting those particular pages and ready for trial for him. He's standby counsel, and that if he would like it,
I know, but if Leo Cover wants it and he's ready to represent himself, he's entitled to ask where to get it. He doesn't have to
He's-
go through it.
he's been able to view it, Your Honor. Yes, he's been able to view it, take notes on it, and
Why can't we make copies of it?
it's a large number of pages in those documents.
That's not what he's saying. He doesn't say it. That's not what he's saying.
I
He
want
says-
10% of what he's got. He's got over 5,000 pages of documents.
10% is
from one
500
day,
pages.
one picture.
10% is 500, just make
When
that.
I go to court,
Okay, I agree with you. I'll make the hard copies for him.
Your Honor, there's nothing that's given as far as what pages he wants. He didn't write any of that down. He just said he wants the however many pages. See, now he's saying the opposite.
Well,
There's not a limited number of pages that he has.
But which is
Okay,
you got to articulate what that is.
well,
So-
there's some of it that I don't want a copy of.
Okay,
at all.
but do you know what that is?
No, Your Honor, and he had a notepad, and we asked him to, that's what I was explaining to him, Mr. West could help him
What
do
about
that, and he said that he doesn't want Mr. West to help him.
Well, somebody's got to tell him so they know. Sam, you say 10%, I'll do 500.
That's, I'm asking on certain ones. I don't want copies of all of it because there's some of it that I know what it is. But you have this thing that's called Diana's documents that I looked at that's made on a computer. That's nothing's verified that it being right on there. You got messages and pictures that were a year apart posted on there. And if this is going to be used against me, I want to be able to go to it when it's brought
I
up
don't know what he's talking about.
so I can argue with it.
Your Honor,
He says me, but I.
there's
It's not me.
it's essentially a Facebook account download of all the messages and things on there. But again, that would be thousands of pages, and he's not specifying which pages.
500. About 500, right? That's what you're saying, 10%.
Your Honor, but I can't read his mind. I don't have these listed. If he has 500, he would need to specify which 500. He had a notepad as well
Hold
as,
on, what are you gonna do?
I'll do that.
Okay.
if he could do that, I mean,
How
I
you
can
gonna
try
do
to get
that?
that.
Write it on some paper or something?
Yeah,
Can you do it now?
I'll do it whenever. They didn't give me paper. or
We'll
pen.
give you some paper if you wanna go in there with you,
I sure will.
and then Mr. West can, if you
No.
need to ask him something, He's standby.
If I can say something, this would be real easy. I'm accused of posting one picture on July the 30th, one day on this person's Facebook page.
Okay.
If you just show me the Facebook page, the picture posted on it, and that it come from me, my phone, I'll come in here and plead guilty and take the
Well,
stipulations and everything else.
Okay,
with
but
it,
you
but
can't-
it doesn't
I'm
exist.
not the one you deal with.
That's what I'm looking for, and it doesn't exist.
And Your Honor,
What about
I've
that?
explained to Mr. Gover that he has Mr. West at his disposal to be able to help him with that.
He's asking at representing himself for that. Do you happen to
Your
have?
Honor, we believe the evidence will
You
show
don't
that,
have
but I'm
that.
not gonna pick through and give him what specifically he's looking for out of this. That's his job. He wants to represent himself pro se.
Well,
so he can go through it and
told you
find
what
it.
he asked
Yes, sir.
for. Do you have something like
The,
that?
Your Honor, there's more than one photo that was posted that's tied to his account, and there's gonna be, that's for us to argue before a jury whether or not he's gonna accept that came from his account or not. I don't think me showing him that's in all those.
But sure, that's your obligation, not his.
No, I've given him that, Your Honor. I've given him the
Oh,
access.
you've
to
given
it.
him-
He's had access
just
to
that.
all of that. Yes, sir. He's had access to it. He, like I said, he has access to all of our discovery. If he wants to look through that and find, what we're alleging in there, that is in those photos, that is in the stuff that's in there. That's why I told him that Mr. West is there to assist him. He's not going to try the case for
Let's
us.
say he doesn't want to, he'd stand by. If he wants to represent himself, he's entitled to do that.
Right, Your Honor. But then he has to do the work of going through here and finding what he wants out of
Give
this
it to him.
discovery. I've given it to him.
Wait.
Where's it at?
He's wanted me to specifically select stuff to give to him. I've given him all the documents. And so as
Mr.
far as
Weber, has he
being,
given you a
he's
bunch
had
of
access,
documents?
he's had access to all
Has
the
he given
documents.
you a bunch of
All
documents?
right. In the documents that I seen, I did not see the complainant's Facebook page with that picture.
Does
And
that
I-
exist or not? You're the prosecutor. Does that exist?
Yes, Your Honor, that's what we've alleged and also
Can you
by
pull
the
that out?
officers.
Can you find that and give it to him, please?
Your Honor, it's in the discovery.
Could you pull it out of the discovery? This is a war of words, and I'm not gonna be in the middle of it. Give it to him, and that will satisfy him.
I've given, Your Honor, I've given him this. I've given him all of it to be able to go through it.
Well, you know what it is. Find the item. It's one single item, please. Pull that item out that he's asking.
It's several pages, Your Honor, and he's
To pull out the
he's
separate
not,
pages.
I wrote my things down on the affidavit of probable cause. And even on there, the detective puts the phone number this was sent from. She owns that phone. I don't. It was synced to mine. And it's written right there, black and white, right there in the detective's report.
Just
So I
You gave
want to
it-
see the picture.
whatever if you have it, can you go through it and pull it, and we'll make copies for him?
To show him, and then he can show me if that's the way you want to do it. I'll go with Mr. West, and then you can show him and he can show me, but I'm saying it ain't happening. Because I know what I didn't do.
He's asking for one particular item. You're in control of those items. Give it to him.
Your Honor, I will print all of it and give it to him, but
No, you can't find that one item. He's
I can
asking.
print all of it, but I'm not doing his work for him. That's not what I'm required to do, is do his job for him. That's not,
We're supposed to have a speedy trial too, and I've been here
I can
25
give you-
months on a 2 years.
and I've given you all the discovery to look.
All right, y'all are not getting it done. He wants the item. Would y'all figure it out what it is? Oh, okay. He said he can go with John into the other room, give him all of that. John is going to be there, making sure that it doesn't get chewed up, spit out, or swallowed, and go through it. And then what he decides he needs copies of, we'll make copies right now. Okay,
Yes.
John, would you help with that, please?
I'm here.
Thank you. You and Leo, take care of that. Thank you. All right.